welcome. Got a nice webinar today on HR in British Columbia, great province of British Columbia. It's a great chance to send any questions you might have about HR in the province. Darcy's going to give a presentation, and then there'll be an open Q&A. This is being recorded, and it will be sent out on Monday as well. And that's pretty much the spiel for everything. So it's always interesting to learn about things that have happened in BC and other provinces as well. Obviously, this one's on British Columbia, and I think, Darcy, it's our second largest market outside of Ontario, if I'm correct.
It is. So we
Yeah.
have Ontario, like our big Ontario, BC, and I think Alberta, and then of course Quebec with our Quebec arm, Exact RH, is doing incredibly well there. So we're multi-jurisdictional for sure.
Okay, so we'll formally start. Welcome, everyone. I'm Brett. This is Darcy. We got a great webinar today on HR in BC. And Darcy, I guess over to you. And if you have any questions, send them away. It is being recorded. It will be sent out next week on Monday. And it's a great chance to send any questions you might have on HR in British Columbia. So over to you, Darcy.
Awesome, thanks, Brett. And yeah, nice shirt. So I'm gonna do the compliment this time. So yeah, and thanks, Sony, behind the scenes. There's a man behind the curtains that makes all this happen on the tech end. So yeah, thank you. Yeah, looking forward to this webinar. We've been doing this quite a bit lately. We've been very jurisdictional specific, and we found that our clients really appreciate it. So we're gonna hit BC today. For a lot of you who attend some of our webinars, there might be a little bit of recap. So we're going through the things that here, I'll throw up the slideshow just so we can talk to or look at what we're speaking to. But we're talking about what would be HR essentials for employers in British Columbia. So amongst those things, like one of the things, obviously, for any company in any jurisdiction, an HR essential would be your employment agreement. So we just did a webinar on employment agreements. So there'll be a little bit of recap, but you're going to see as we go through, a lot of this is very BC specific. We talk about some case law that's relevant, some of which is super important, and for a change, super good for employers. So BC is quite distinct that way. So I'm excited to talk about that. So let's just jump right in. The HR essentials for small and medium-sized businesses in British Columbia. So here's what we're going to kind of review today. We're going to talk about the construction of the employment agreement. So again, for those folks that were on last week, this will be kind of a review. If you have questions, as Brett suggested, great opportunity to submit them. We'll get to them after this presentation is over. We had a lot of questions from the EA, the employment agreement webinar, that were left unanswered because we ran out of time. So this is a great time to catch up. Termination clause. This is a big deal, not only about the employment agreement, but how you handle terminations in British Columbia. Again, this is one of the areas that British Columbia is distinct to every other jurisdiction in Canada. It's recent, it's good news. I'm happy to be able to share it. I'm hoping it kind of travels through jurisdictions, travels our way as well. Key HR policies and processes that that you must have in place in British Columbia, but also that you should have in place in any jurisdiction, including British Columbia. And finally, we're going to talk about 3 specific policies that a lot of companies don't think to include in their policy manual, or if they include them, they're not done properly, which makes them unenforceable, and having an unenforceable policy, I hate to say it, but having an unenforceable policy in your policy manual is worse than having it at all. So we're going to talk about drugs and alcohol in the workplace. We're going to talk about social media. We're going to talk about the progressive discipline policy, which almost every employer has. It's just about 80 to 90% of progressive discipline policies and the paperwork they use in the process are not enforceable if you get to the end and you try to terminate somebody with cause. So we're going to talk about all of that today. We'll try and be around the 25-minute mark. That would give us about a half hour for questions. And I know we already have some questions coming in, but again, throw them in there. We don't want anyone to be left like it has been the case for the last few webinars we've done. The construction of the employment agreement. So right out of the gate, these are the things that every good employment agreement should have. Right? So to start off, you clearly want to indicate what the status of the employee is, the method of payment, qualification of hours, location, and working arrangements. This is important. The employment status and the method of payment are important. There's too many employers still, no matter how much I get on my webinar and preach, and no matter how much Brett sends out the good words to all of our partners out there, there's too many employers out there still that think that if you pay somebody salary, that means you do not have to pay them overtime. That means that whatever they're working, whether it be 40 hours a week, 50 hours a week, 60 hours a week, that's what they get paid. That's not the case. Status has nothing to do with the method of payment. Getting paid overtime has something to, it's either exempt status or not exempt status. In other words, if you're a manager, you're exempt. You don't get overtime. It doesn't matter whether you're paid by wage, whether you're paid hourly or by salary, you're not entitled to overtime rates, so the time and a half. If you are non-exempt, in other words, you're not managerial supervisory 50% of the time, you're entitled to overtime rates. It does not matter that you get paid salary. It has no bearing whatsoever. Things like, location and working arrangements also important. If you're one of those businesses that has more than one location, then you want to make sure that every location is named in your employment agreement. Elsewise, you will be deemed to have a central location, and whenever you go from one location to another, it will be considered work time. And there also might be the potential, depending on your policies, whether or not you have to pay mileage or not. The type of agreement, it seems pretty basic, but nowadays employment agreements, you have to be clear about whether it's a seasonal agreement, a permanent agreement, fixed term agreement, casual, etc. The fixed term agreement is causing causing employers a lot of grief, because a lot of fixed term employment agreements just have an approximate date at the end, or end of season, or what have you. It doesn't have a specific end date. And if you don't have a specific end date in a fixed term agreement, it's not a fixed term agreement at all. It's a permanent agreement. It's a wolf in sheep's clothing, if you will. Okay, so it's super important that if you have a fixed term agreement, that it has an end date. If you terminate anytime before that end date, you could end up having to pay out the entire duration of the fixed term agreement if you don't have a good termination clause. If you terminate after the end date, then you have to pay termination pay, which includes common law. Because once the end date is surpassed in a fixed term agreement, it is considered a permanent agreement. So that's important to keep in mind. Preconditions of employment. This is critical for any. I just had a question today from an employer in the United States who's hiring someone in their accounting division, and they wanted to know if they could do a credit history check. It's part of the bona fide occupational requirement of the job that they're going to be handling money. You might have access to said money if they did something wrong or illegal. So it's right and it's proper, it's appropriate that they would be able to do a background check. Now, here's the thing. They need this person now. So they could put a precondition of employment in there that basically states that you will provide us with this credit check within 14 days. If the credit check should not check out, your employment will be terminated without cause. No further things will be owing, et cetera, et cetera. That's the importance of a precondition. Once you've signed the agreement, if you down the road, you want to ask for a driver's abstract or you want to ask for a criminal record check and anything, they do not have to provide it to you. They do not have to provide it to you. The employment agreement is the time and place to get that done. Policies and contractual terms. Again, the employment agreement is the opportunity. It is your contract. It is a contract. So this is the opportunity for you to kind of lock these things in. So when you get an employee to sign an employment contract, you should be presenting them with the policy manual at the same time. You can't sign up for a mortgage and say, hey, you sign up for the mortgage. And then after they signed up for it, here's the terms and conditions of the mortgage. It doesn't work that way. If you want policies to be part of your employment agreement, a continued condition of employment, they need to see the policies before they sign the agreement, or there has to be something in the employment agreement that references the policy manual. You could do the same thing with job descriptions. I'm hesitant to put that in here, but I do because I know some HR folks and some employers believe in putting your job description in the employment agreement. I'm not a fan. Job descriptions change over time. It's organic. Jobs do change. More responsibilities are changed, responsibilities are added on. If you ever went to formally change a job description and it was referenced in the employment agreement, you would need to provide consideration to your employee to change the employment agreement. So things that will change over time that are day-to-day operational or organic really shouldn't be in your, at least I believe they shouldn't be in your employment agreement, because your employment agreement is a contract and you can't unilaterally change it after it's signed without having to pay the employee to have it done or give them working notice, which is another thing entirely. Other important terms that should be in your employment agreement, and we're not going to touch too much on these today. I feel at all. I think this is the one slide for it. Layoff clauses. So in any jurisdiction in Canada, any jurisdiction, you do not have the right to lay off unless you're a seasonal industry where it's expected that you would be laid off, or in the case where you have it in your employment agreement. If you do not have the right to lay off in your employment agreement, then you can't lay off somebody. It's considered constructive dismissal. The courts have been very clear about that. They maintain their stance through COVID that it doesn't matter what the reason is. If it's not in the employment agreement that you have the right to lay off an employee, it is constructive dismissal. When they signed up with your company, it wasn't an expected term of employment that they might have to go without pay for any length of time because you're going through financial difficulties. So it's important. Of all those things, that's the one thing that definitely should be on there. And then your restrictive covenants. Okay, your restrictive covenants are things that protect you. These are the most important thing in your employment agreement. I know employers out there, they don't like the 6, 7 page employment agreement. They think it's gaudy. They want it easy for their employees. This is your one opportunity to make this happen. This is your one opportunity to say, hey, if you want to work here, you have to sign this contract saying you agree to all these things. If you don't want to work here, that's fine. Don't sign the contract. Oh, if you don't like the terms, don't work here. But that's your one opportunity where you have 100% leverage. It's super important, even though it's about 2 to 3 pages of legal language. The termination clause, the non-competes, the non-solicit, the exclusive services, these are all things that you need to take the opportunity to put. The termination clause is something we're going to speak about specifically, and here we go. So this slide is typically for every other jurisdiction in Canada and for BC up until just recently. This slide was just termination clauses, legal pitfalls. That's it. There was nothing else. You'll notice that the title has been morphed Hope for BC because there was a recent piece of case law, which we're going to discuss in a second, which changes the game for British Columbia more so than any other jurisdiction. Matter of fact, I think most employers should just move to British Columbia and start doing business there because it's that big of a win for employers, well, as it relates to termination clauses. So we'll start into the legal pitfall thing before we get into the good news. The one thing about termination clauses, even in British Columbia, is it must contain clear language regarding entitlement. So this means that it must maintain clear language about what the employee is entitled to as per the Employment Standards Act. Now, the Employment Standards Act doesn't go into great detail about, compensation over and above salary. It doesn't go into great detail about benefits to the statutory notice period, but it does go into specific detail about what they are required to be entitled to at termination. Your termination clause is to be specific about what they're entitled to at termination as per the Employment Standards Act. It can't be ambiguous. It has to be clear wording about what it is that they're entitled to and what it is that they're not entitled to if they sign this agreement. Now, this part here, you'll see here that BC is the only province in Canada right now that is taking a common sense approach. What I mean by that, and we're going to get to it in a second, so I won't belabor it here. But what I mean by that is most other jurisdictions have a very defined way of reading a employment agreement or reading the Employment Standards Act, and they expect that to be translated into the termination clause. BC, they still expect you to be clear and non-ambiguous. However, a recent piece of case law said that you can use some common sense in the way you actually write your termination clause, one, but more importantly, how it's intended, how it's interpreted. So in the Egan case, the EA can limit a termination entitlement to statutory notice periods, but it can also exceed those statutory notice periods if the employer so chooses. And they can write that in there, that we will provide you with 2 weeks, we will provide you with the ESA minimum, and should the employer wish to provide you more, we will do that. That language that I just wrote, so for example, if I said in a termination agreement, you are entitled to the ESA entitlement, which includes your benefits, which includes your compensation, any bonuses, commissions, all these different things which you would have to write in every province. Furthermore, I said that upon sole discretion of the employer, we may provide you more than the ESA. Anything that I just said, those last 2 sentences in any other jurisdiction would make that termination clause void because it could be argued that the clause was ambiguous to the point of the employee could have expected more. And if the employee could expect more, the courts have ruled in every other province and British Columbia up until this year that they are entitled to more. That it's not right for an employer to say you might get more and it's at our discretion that you may or may not get more. If it says you might get more, you get more. In 2024, that changed. Here's the logic behind it. Now, I will caution, I will premise this, and I'll explain it in a second. I did take some of this right out of the legal decision. So, because there's no other way, it's so precise, there's no other way I could say it, right? The difference between this piece of case law and what's happening. And so for those people in BC that have other entities or have employees in other provinces, which means if you're a BC employer, you have an employee in Ontario, for example, you have to have them under an Ontario employment agreement. You can't have them under a BC employment agreement. It doesn't apply. So in this case, your level of what the bar of termination and just causes in your employment agreement being able to hold is going to be different in BC than it's going to be in Ontario. So it's important to keep that in mind. Notice periods are prescriptive in BC. Okay, as opposed to the languages and other languages like Alberta, Ontario. Basically what this means, and you can read that, and this will all be sent out to you so you can read what's on the slide. Basically what that means is that in BC, the languages are written as, this is the way it's written, This is the way it's intended. That's all, like, that's it. Like, you follow the rules. It's fast and rigid. Where in other provinces and jurisdictions, it's not prescriptive. So, and what I mean by that is, yes, here are the rules, but the application of the rules can be, kind of viewed in a different way, or it can be viewed to have some different outcomes. Hence, because it can be viewed to have some different outcomes, then you have to be very specific in your termination clause about what they're entitled to. BC is not that way. Here's the rules. They're rigid. As long as you include the rule that you were entitled to what's entitled, what you would get to the ESA, and say only that, say only what's prescribed to by the, the Employment Standards Act, you're fine. So long and short of it, the termination clauses that you see getting struck down across the country and have been struck down in British Columbia up until just recently are not so easily going to be struck down anymore. If the intent of your termination agreement is to say, listen, if you're terminated, when you sign this agreement, you acknowledge and agree that if you're terminated, you will only get the ESA minimums and anything else that the ESA prescribes that you're entitled to at termination. And that common law is not a presumption you're allowed to have once you sign this agreement. If that intention is clear through the entire employment agreement, not just the termination clause, but through the entire employment agreement, the courts will uphold your termination clause in British Columbia. That's a big deal, because there's literally, and I'm not even exaggerating, billions of dollars in termination payments that are being spent, or settlements that are being sent and spent by employers across Canada just in the last few years alone, after all these changes in Ontario and Alberta specifically, right? So BC is kind of made, usually they're the ones, Ontario and BC are typically leaders in a lot of things, and BC typically does follow Ontario employment law and legislation on a lot of things. BC kind of broke rank here. They took a more common sense approach. It's refreshing. It's great for employers. So for all of you people in British Columbia doing business, HR people alike, good on you. It's a win. We don't get money. So it's what it is. So the only other thing you have to be mindful of termination clauses in general is they have to be clear in their application. If you ever have to change your termination clause, or amend your employment agreement because the termination clause was, under case law scrutinized and you have to change it, you have to provide fresh consideration to the employee. So whenever you update your employee, your employment agreement, you have to provide something of value to the employee in turn, which means and if something of value could be anything. It could be a bag of chips, it could be a raise, it could be a Friday afternoon off. As long as there's something that the employee values, then it's a contract. Both people are getting something into the contract, which makes it enforceable, which includes the termination clause. Moving right along, we're making pretty good time. So hopefully I'm not talking too quick, but that's why we record it, because people can go back and put me in slow motion. Key HR policies and processes that you need to have in your policy manual. A lot of this travels. So a lot of this is multi-jurisdictional, but there's a couple things that are specific to British Columbia, especially around the things that aren't required, the things that you should have in there that most employers do, but something to be mindful of. So first, I always start off with the legal benefit of a solid policy manual. Now, I will say this, I'm a different type of HR person. I'm kind of the employment law hammer down kind of HR person. I'm not the touch and feely blue sky thing. So yes, there's definite things about a policy manual, like providing guidance and being reflective of your company culture and all of that stuff I don't care about. I do, don't get me wrong, but for the purpose of what we're talking about, this is what a policy manual is for. It's to set expectations for the employee, their performance. It's to help defend against employee claims, and it's to to defend against legal disputes. These are the rules of the road, if you will. When someone starts with you, the employment agreement defines the terms of the arrangement, but your policy manual defines the terms of employment while it's happening. They're super important that you have a well-written policy manual, because next to the employment agreement, which is the most powerful document in the entire tenure of your employment relationship, your policy manual reinforces that. And that's why it's important that you mention the policy manual in your employment agreement, so it has that same type of enforceability. Oddly enough, most people think that there's a ton of required policies that you're required to, or a ton of policies that you're required to have in a policy manual. It's not the case. The vast majority of policies that you're required to have in policy manual, legislatively required, are health and safety, and it's typically industry specific. And we'll touch on that really quickly. So health and safety awareness policy, a workplace harassment policy, workplace violence policy, if applicable, a WMIS policy. Typically in most jurisdictions, BC, there is an accessibility policy as well, so that should be in there. So, but these are the policies, there's only a handful. If you really wanted to get by, even though I highly don't suggest it, if you really wanted to get by with the Ministry of Labor, the Labor Board showing up your door tomorrow and saying, I want to see if you have your legislatively required policies in place, there's only a handful of policies you must have. They must be written in a certain way, but you have to have them. Operational policies, though, are an employer's best friends and an HR department's best friend as well. These are the things that where the rubber hits the road, defines you, protects you, give you guidance, allows you to, kind of rule the roost, if you will, and provide structure for your employees, because these do benefit your employees in some way as well, but definitely structure for which you expect your employees to follow, which helps the business owner, which helps the CAO, CFO, and the HR people, right? So hours of work, overtime, vacation, PTO, personal time off, benefits, like a benefit, a benefits policy, for example, we have this all the time with our partners in the benefit industry. If after 2 years of an employee being off and you say, okay, they've been off for 2 years, we don't want to have to pay them benefits anymore, but you didn't have a benefit policy that specifically said that you could stop paying benefits after 2 years, you can't cut off their benefits. If you do, they could sue you for discrimination under the Human Rights Code. Right? Because the reason you're taking away their benefits is because they're off on a leave, they're off on a disability. That's discrimination based on disability. If you had a policy on benefits that said after 2 years of being off, that we have the right to stop paying premiums on your portion of on our portion of the benefit plan, then you're fine. Right? So that's why these types of policies are fine. The performance management one, I love this one. This is a great case that I stumbled across. I actually stumbled across it last night, and doing a little bit of research about BC specific, more so than I usually already do. But the Chow versus China case, this is a great example where, begging your pardon, you had an employee who had been working there like for well over 10 years, but he was getting older in his years. The guy was 60, or he was in his late 60s. He had no intention of wanting to retire, nor were there any signs of him wanting to retire. All of a sudden, after 10 years as a manager, being constantly promoted through the ranks, all of a sudden the employer decided to start doing performance management on this employee, right? And then the next thing came was a PIP. And then they started saying, okay, he's not working fast enough, so we're going to give him, we're going to say he did time theft, and we're going to bust him down and give him a lower position, a front desk position with 25% less pay and crappy hours. And then a year later, they terminated him, right? At the end of the day, the employees sued. They sued for discrimination. They sued for wrongful dismissal. The wrongful dismissal case is what we're talking here. But at the end of the day, this employee was awarded, I think it was $218,000, right? The number one reason outside of the egregious and, basically spineless thing that the employer did in this case, the number one reason, so I guess number two in that case, was that the employer did not have a performance management process in place, nor did they do it regularly. If you do not have a performance management policy in place, good luck trying to have anything that comes out of a performance management policy stick. If you have a performance management policy in place and you don't do regular performance management and you just swoop in on an employee that's doing not that great and start to insert performance management, it will not hold up in a court or a mediation or arbitration. You have my word on it. Performance management needs to be non-punitive from its nexus. It can only turn punitive after it's been going on for some course of time and there's been a history of poor performance. In this case, this not having this performance management policy and not doing regular performance management costs this employer over $200,000. So that's a costly lesson about what we're talking about here today. Human rights accommodation. So human rights and accommodation are absolutely policies you should have. Human rights in general, it's not even a requirement of legislation anymore, and it is in most jurisdictions. But what it is, it's a requirement of your company culture and your brand. Most companies, when you're doing business with other companies, require that you have some type of corporate ethics code or some code about human rights or some code about pay equity, no to slavery, things like that. So human rights and accommodation policy is super important. And here's a great one. This is an important one too. It's one of the two really big ones that, obviously the termination one being a big deal. But BC's had some fundamental changes in case law in the last 2 years, the one being the termination one, this one being the other. Up until recently, if someone claimed family status as a need for an accommodation, in other words, these two people just came back from mat leave, and the one person came back from mat leave, but both of these people worked at the same company doing 12-hour shifts, and they've been working there together for 12 years. The wife came back from mat leave and asked for an accommodation so they could be able to accommodate childcare, be it that they both worked 12-hour shifts and there was no other way they can do it. The employer denied it. Basically said, this is what you signed up for. We understand that your circumstances have changed, but we haven't made any changes to your agreement or your employment terms, and we're not required to. If we made changes to your employment terms during, your mat leave or thereafter, then yeah, you could sue us. You could say that we discriminated you on the basis of property. And this has been upheld in British Columbia for decades. It's the Campbell River case that if anyone does case law, sadistic like me and has no life and just reads all the time. The Campbell River case for years and years and years was the presiding case, which basically says it requires a change in condition of employment in order for there to be considered discrimination on the cases of family status. That's no longer the case. There does not longer, if the employee's conditions change, they have the right to come and ask if they can make a strong enough case. And in this case, they both work 12-hour shifts. They both work for the same company. One of the two of them had to have some type of accommodation, or they weren't able to provide appropriate childcare. Hence, the judge ruled that it was, in fact, discrimination on the basis of family status. Huge case. It basically means when your employee's life changes, they are entitled to accommodation if they ask for it and make a case. Never used to be that way. Right? The employer had to the employer had to actively do something for a discrimination claim to come forth. Now something can happen in the employee's life, and that could be the nexus for a discrimination claim. Jurisdiction or industry specifically, so especially around health and safety, like if you get into, mining, farming, manufacturing, industrial construction, you outside of the regular policies that you're required to have, there's going to be other jurisdictional specific, and the list would go, there's hundreds of policies that it could potentially be. Sharps in dental and medical or anywhere else where, ANITA would be needed. Iron stations, forklifts, chemical showers, etc. Working at heights in British Columbia. British Columbia, again, one of those, probably the province who was paramount in first bringing out working heights, like high-end standard working in heights requirements in Canada. So, those are things. And then the three we're going to talk about. And we are almost at 4:30, so I'm going to go through these next three really quick. But these are important policies. I'm going to give you one underlying trend for the next two that's super important. Drugs and alcohol and social media. Drugs and alcohol are legal. Most drugs are legal. Prescribed drugs are legal. Some, drugs that never used to be legal or are legal are now legal. And certainly alcohol is legal, right? You're allowed to smoke it. You're allowed to take it. You're allowed to drink it, right? Same thing with social media. It's you're allowed to go on social media and say pretty much whatever the hell you want, right? Employers assume that if somebody comes into the workplace hammered, that they can terminate them, but yet it's legal to get hammered. So unless you have a workplace policy that states you cannot do this, right? You cannot come into our workplace under the influence, smelling like alcohol, what have you, then you can't touch them. You can let them go, but you're gonna have to pay them out. And that would suck, right? You have somebody that comes into the workplace clearly not fit to work, clearly intoxicated or under the influence. You end up letting them go, but because you never had a policy in this subject, bringing this into your workplace, because right now it's out there. People are allowed to do this. So if you don't bring that authority for them to say you can do this, you just can't do it here. And that's what a policy does. You can't terminate somebody for cause in any Canadian jurisdiction unless you have a policy, right? For cause terminations. Again, same thing I just mentioned, that you can terminate them, but you can't do it unless you have a policy. Reasonable suspicion. This is a big one too, and this speaks a lot to drug tests and things of that nature. And when you could say somebody should be and should not be in the workplace. Technically, when someone comes in and they're under the influence, but you're not sure, even if you're pretty sure, the process that's supposed to take place is that you're supposed to go grab another manager or another person of authority, and both of you individually are supposed to assess certain things. You should have a checklist. So if you're an HR cover client, you would have a checklist from us that states, it's a 2-page checklist. This person is swerving their eyes. This person is slurring their words. This person smells like alcohol. Each person would fill it out separately. You would come together, and if it looks like this person, if you corroborate on the fact that this person is under the influence and agree, then you can send them home, and then you can deal with them the next day as far as ramifications goes. Drug testing, and I know in the Western provinces, Alberta, especially in BC to a little bit lesser extent, but definitely there, drug testing is a big thing. You cannot do drug testing unless you have reasonable suspicion. You have to have cause to do drug testing. Drug testing before somebody starts work, even in a safety sensitive industry, is not allowed in Canada. There's companies that do it, they pay their fines and they move on, but it's not allowed in Canada. It's a violation of the Human Rights Code, right? This case here in the Innifor Corporation case, what ended up happening is they had an actually quite excellent policy in place, and the court acknowledged that their policy was quite excellent. That after an accident that has a reasonable suspicion of being due to the impairment of drugs or alcohol, you have the right to do a drug test. In this case, this person who people thought, likes to drink at night, it's, a rumor, you're totally allowed to do that, rolled over their forklift and a whole bunch of canisters fell off the forklift without anything more than the idea that it's possible that this person might have been under the influence. They ordered a drug and alcohol test. This person claimed discrimination under the code and they won. Basically, the long and short of it is the fact that a accident happened and the strenuous test that it is that you having reasonable cause, you can't just jump to the worst case scenario and say, it is possible that this person might have been under the influence, so we are going to test his privacy rights and violate his privacy rights and his human rights and give him a drug test because it's possible. You actually have to have substantive reasoning before you could put somebody in a position to violate those rights, which are their human rights, their inherent human rights, which includes privacy. So that's a big case. This is, again, 2022. So this is relatively recent. So we're talking about the up-to-date case law in the matter. So keep it in mind, it's great that they had a great policy, but implemented wrong, it doesn't go well. And then human rights. So if any of you do have a drug and alcohol policy, if you don't have something in your drug and alcohol policy that acknowledges that if someone has a dependency or an addiction to drugs and alcohol, and that will be asked of them in the process of, encountering them in the workplace under the influence or allegedly under the influence, if they are given that opportunity to say, yes, I have a dependency or what have you, you can't touch them right away. You can't. You have to offer them support, right? And if someone at any point during that process comes forth and says, you know what, I believe I'm being addicted, you have to offer them support. There's a whole process that looks like. I go through it with my clients all the time, typically, unfortunately, after they've already let the employee go or after they've already disciplined the employee. And then we try to walk it back to say, no, you can't do that. But there's a whole process. We could do a whole other webinar on that all by itself. But it's really important that if your policy doesn't specifically state what the human rights and the protections are afforded to in the policy, it's not enforceable. It actually, on its face, it would be a violation of the Human Rights Code. Computer use policies, I'll go through this a little bit quicker because the principle is the same, is that you are allowed to go on and say whatever you want in the workplace or on social media, especially after work's over, right? You can say whatever the hell you want. It's neither here or there. And because of that, like, you could get sued, and you could say you could talk about your employer and gets, but if you don't have a policy in place that states that this thing that employees are allowed to do is coming into the workplace and we're going to restrict rules about it, then you can't touch them. You can't terminate them with cause. Again, you could sue them for slander, you can sue them, for a whole bunch of different, but you can't terminate them for cost, right? So some of the things that you should be telling your employees and as a best practice, right? Because oftentimes with social media nowadays, with politics and everything and what have you, and we're going through this in the States right now, there's a lot of strong opinions one way or the other. But with all of that, it's important that your employees have some kind of guidance. One of the things that's critical and key is that employees don't tie their employment to their social media pages. So, Facebook, and I'm dating myself when I say Facebook. I know there's 1,000 other things out there that I don't claim to understand or want to know about. But Facebook, it asks you, it gives you an opportunity to say where you're employed. As soon as you put your company's name in there, anything you say on that Facebook page, even after hours, if you have a policy, if you don't have a policy, they can say whatever the hell they want. Too bad. But if you have a policy, anything they say on that Facebook page, because their opinions now are automatically inferred upon the employer because there's a link, can be subject to discipline up to and including termination with cause. So it's super important to inform your employees, try and keep your social media separate. It's not necessarily going to protect you, but try and keep your social media separate from your work. Derogatory, defamatory, inflammatory language, words and pictures implying legal conduct or activity, all these different types of things. These are things that, whether it be at work time or non-work time, should be included as examples of what's unacceptable on social media. right? Security, remote access passwords, these are things for your computer use policy. In the remote and hybrid work time that we live in, it's really important that your policy includes protocols to protect not only the company, not only your, your own information, your own confidential information, but whenever you allow someone to take a laptop home, or whenever you allow someone to work from home, the actual information, which is your clients, the actual information that is, could get out there that could harm you, that's on the employer. Even if the employee screws up, it's on the employer. That's who is liable. This is the way you protect yourself from making that happen. Okay. And then finally, electronic monitoring. This is now a law in Ontario. I expect it to become a law in BC as well, because they follow each other on these types of things, and there's already indication it's going to be tabled. But it's really important to know that whenever you are monitoring somebody, as an employer, not as an employee, unfortunately, but as an employer, you have a legal obligation to tell them that you're monitoring them, even if it's your equipment. You have to let them know that you're monitoring it, why you're monitoring it, and what's the consequences of happening if they break any of these rules. So that's super important. Finally, progressive discipline, then we'll hit some questions. We went over a little bit, but there's a lot of important stuff here. Progressive discipline must ensure consistency and equity in the progressive discipline process. It's super important, right? One of the things, what I've found is that subjectivity, especially when you get into a union environment, discipline cannot be subjective. So in a unionized environment, you could argue over there that this person was given this discipline for this action, and this person was given a different level of discipline for this action. If that was to be grieved, that by itself would be enough to say, hey, we're going to drop your grievance. The discipline no longer holds. You have to be consistent in your approach. In a non-union environment, same thing. If an employee finds out that people were disciplined differently for the same action, it could lead to legal recourse, but it also leads to cultural issues. Like it leads to poor culture in the workplace. When employees know that, the favorite of the boss did this and got a slap on the wrist, and then this person over here did the exact same thing and got a second written warning, that's problematic, right? This case, I love this case. I admittedly, I love this case because it's about what, as human resource professionals, I would like to think anyways, that we stand for. Not all conduct or behavior is equal, right? So if someone comes in and they walk up to their boss and they punch them in the face, right? And then another person is late 3 times in a month, the disciplines that are going to be issued for each one of those things should not be the same, because the conduct is not the same, right? They're definitely, even a non-reasonable person can understand that doesn't equate in the same path, in the same world, right? So here's a case, for example, to the point, progressive discipline has steps. If the action merits it, it's your responsibility to identify with the right step where that person should land. Being late a few times might get you a warning, right? Open subordination, sexual harassment, verbal harassment, that should never start with just a first warning. You should always be skipping something, especially if it was the outcourse of an investigation. And it could be termination by itself. It could be egregious that much in and by itself. In this case, there was a person who was accused of sexual harassment. They did an investigation. The investigation found that, in fact, this person did sexually harass another employee. The employee, and this is novel, the employee actually said, I take responsibility for my actions. I will resign, or if you terminate me, I will accept that. The employer, so moved by this employee's, kind of sorry, if you will, said, you know what, you could keep your job. You just have to write a written apology to the employee. The employee, for whatever reason, refused to write the written apology. The employer fired them. The employee that just got fired, who just got, found to have committed sexual harassment, then sued the employer for wrongful dismissal and won. And the logic being, and it was very clear, that employer had a legal obligation to terminate that employee when they found out the sexual harassment was committed, investigated, and the extent and nature of the sexual harassment was as such that it should have dictated a termination. So not only did he lose $88,000 in a wrongful dismissal suit for a person who just actually committed sexual harassment, I think that he received about $30,000 in fines from the Ministry of the Labor Board for not doing his obligation under the act. You have an obligation to protect employees and give them a safe and, safe and respectful work environment. When you say to someone who committed sexual harassment, if you write a letter saying apologize, you can have your job back, you were forgoing your obligation. So a whole bunch of fines, a whole bunch of embarrassment, and a whole bunch of money he had to pay out because he didn't follow the process. We're almost done. Sorry. Documentation. 99% of the time, 99% of the time, when I review a case where something didn't hold up for progressive discipline termination, it's because of this. The policy itself is usually okay. Progressive discipline policy itself is not super complicated. The one hang up is the first level, which the verbal warning or the counseling session, as I like to call it, that has to be non-punitive. It cannot be a disciplinary step. That's where most progressive discipline policies fail. In this case, it's the letters. Every letter must clearly state the cause of the discipline, the level of the discipline, the expectations for improvement, and most importantly, and it will never hold up in a court unless you're very specific about this, the consequences of doing it again. So after you receive your first written warning, it should say you will be, if you do this again, you will receive further discipline up to and including termination with cause. Until you get to the last written warning where it should say you will be terminated with cause. There should be no ambiguity there. If the next warning, if they do exactly what they did again, and you put you may be disciplined or you may be terminated with cause, it will not hold up in a court. You have to be clear about what the actions and outcomes are and how they correlate. And if it's not clear and unambiguous, it won't hold up in a court. That's where most progressive discipline policies fail. And then remember, and this is super important, unless you're in a union environment, when you discipline somebody, there's no recourse for the employee. The employee doesn't go get a lawyer or go to the lawyer board or whatever and say, I got disciplined and I feel wronged. They're going to say there's nothing in the ESA that states that discipline is not a management right. So all these disciplines you do, and this is tough a message, or it's a tough lesson for an employer to learn because you only learn it at the end. The only time you will know if you did your disciplines properly, if your discipline letters were appropriate and what they needed to be, is when you go to terminate with cause. When you go to terminate with cause, the judge or the mediator or the arbitrator, or what have you, will go back and look at everything you did, every letter you wrote, every step you took. And if any single one of those steps or processes were not done properly, the end result will be for that discipline with cause to be thrown out. So when you're going to follow the progressive discipline process, the steps and following procedure and being consistent and having the right things in each letter are super important. That's it. That's my dog, who's been amazingly quiet throughout this whole presentation. So I'm really happy about that. So yeah, no, hopefully everybody tried to make it as BC specific, a lot of great case law. Happy to answer any questions. Hopefully you got something out of it. And yeah, I'll turn it over to Brett.
It's great, Darce. Thanks. Very interesting stuff. Let's jump into the questions. Okay, question number one. The hours of work and overtime required for employees in BC are a little bit complicated and expensive for our company. Is there a way we can manage our costs for overtime?
Yeah, Alberta and British Columbia have the same kind of burden. Most jurisdictions just have this is your weekly rate if you go over your weekly number of hours. Ontario and BC and Alberta have that per day overtime rate, per weekly overtime rate. It's so whatever's the greater. So it's complicated. It's not really complicated, but it can be costly, right? You can have somebody that works 30 hours in a week, but works one 10-hour day. You owe them overtime for that 10-hour day. So if you're not familiar with the concept of an averaging agreement, even if you don't have a problem with overtime rates, get familiar with it. Averaging agreements are great. It's one of the few tools that the government in almost every jurisdiction has provided you, especially in BC, that gives you some power to mesh out your overtime. So if you had an averaging agreement that was over 2 weeks, for example, and someone worked a 10-hour day and then a 44-hour week, and then the next week they worked all 6-hour days or whatever, doesn't matter what they work, but at the end of the day, if you combine all of the hours in the 2 weeks, if it's under an average of 8 hours a day and under an average of 40 hours a week, no overtime is owing. It's a great tool, not complicated to put together. We could certainly help you with it. But yeah, averaging agreement is definitely the way to go.
Okay, so let's move on to sick days. We offer our employees 10 sick days per year. Now 5 sick days per year are mandatory, and we have employees saying that they are contractually entitled to 15 sick days. Is that true?
No, it's a really good question because when the sick day thing first came out in British Columbia, the mandatory 5 paid sick days, We got this question a lot. And it's a lot of union mentality and all this kind of stuff that is busting into the non-union sector. And I get it. That's labor employment law actually derives from labor law in a lot of different ways. But what ends up happening is the way the act is written is that yes, you're given 5 days. It's not something that you add on to your existing allotment. The act is very specific that if you're given the same or a better benefit, then this is a part of that. That this doesn't, it's not an add-on. If you know, contractually, if it was the other way around, it's possible that you could, you know, make that argument. But in reality, the writers of that that legislation were pretty careful to say that if you get a better benefit, it doesn't mean that you get it added on. It's your better benefit is what stays. It's no different when someone raises the minimum wage and you have all employees that get paid higher than the minimum wage saying, I want to raise now too by the same amount. No, the minimum wage is the minimum. If you receive a better benefit, the ESA is not applicable. So in this case, for that employer, the ESA is not applicable because they give they give a better benefit. That's the contractual piece of it will take over the legislative piece of it, if you will.
Okay. Are all companies required to have an HR policy manual?
No, it's we kind of touched on it in the presentation. You're required to have a handful of very specific legislative required policies like workplace violence, health and safety awareness, things of that nature. You're required to have that. Does that make a manual? Not really. It does, but you could keep it all loose leaf policies as long as they're in place and your employees have read them and understand them, you're fine. It would be folly for the reasons we talked about with the, you know, the social media and the overtime and the performance management and all the different types of things. It would be folly for an employer in today's day and age where everything is so legal and you will be called to the mat by employees because there's so much more aware. It would be folly for an employer not to have a policy manual. In reality, I know there's some companies out there that still have a few clients that say they don't like it, they don't like the rules. But in reality, the rules are there to protect the employer. Until they get burnt, they don't necessarily, you know, get that concept.
So this is kind of a follow-up to that question. We do not have a discipline policy because we feel it reflects poorly on our culture. Is this a policy we are required to have?
Again, along the same lines, it's not a policy you're required to have. You just have to know this, and this is a trade-off. I actually get the point because I do have clients that don't have performance management policies, they don't have attendance management policies, they don't have things that are like established rules upon their employee, and they want to establish that culture of, you know, kind of like cooperation and, you know, accountability amongst each other, and that's all good. You just have to be aware that for any of those things that you don't have a policy for, you would never be able to terminate that person with cause for violation of what would have been that policy. So if you give someone a discipline letter and you don't have a progressive discipline policy, it's not worth the paper it's written on. The letter has to be part and parcel of the process that's outlined for the employee that they're aware of in advance and when they came on board knows that they were privy to. So, you know, you don't have to have it. I recommend it, but I respect an employer's right to, you know, choose another path if they choose so.
In BC, can an employee use paid sick days for a family emergency or taking care of a sick child?
Technically, no. So the legislation was very, just sort of going back with we do because we're multi-jurisdictional. I do every jurisdiction with the exception of Quebec. Well, most not Quebec. Sometimes my mind gets intertwined. In British Columbia, the language is very specific that it has to be for personal injury or illness. So even though other jurisdictions do allow for personal days or for family emergency days or allow sick days to be used for those types of situations, if you and as an employer wish to say no, I'm not going to allow that, you have the right to say no, and they can use one of their 3 unpaid days.
Okay. We terminated an employee and gave them 5 days to consider the package we offered. The employee told us that we have to pay them within 2 days. Is this correct?
That's a great question because this every once in a while, this sneaks up and bites me in the butt too. BC is that one province that you have to pay, and this is important. This is the important part where you have to pay what is owed within the 48 hours. So you don't have to pay, like if you're giving them a package and then they're telling you, no, you must give that all to me within 48 hours, then I'll decide whether I sell it or sign it or not. That's not the case. what
Right.
they're entitled to, their vacation pay, their termination pay, all that kind of stuff that's entitled to them, either because they've earned it, it has a vacation pay which hasn't been used, the ESA termination, statutory notice, that all must be paid within 48 hours. Then you could have that extra 5 days to say if they want the common law or not. It's a disadvantage, quite frankly. It's an advantage for employees. And I think BC recognized this if you read the working papers about why this was put in. And a lot of, and we're as employer reps, we do this as well. We will try not to give the termination pay when we're negotiating a termination package for as long as possible. Because obviously, if they have funds in their bank account to be able to use to retain a lawyer, then it's more likely that they might see a lawyer, right? In BC, I think that's part of the reason they do that is because give them the money. If they want to go seek legal representation, they have some money to do so. And at the very least, it's more of a bargaining in good faith kind of thing. But yeah, within 48 hours, you have to pay what's legally owed.
We have employees that travel to conferences and events. Are we required to pay for their travel time? Do we have to pay for their entire time they are there?
Yes, and kind of. So yes, you have to pay for their travel time. Travel for work is still travel time. So, you would pay the hours that they're actually physically traveling. As far as the time there, this is always a matter of interpretation, but in reality, I think it's relatively straightforward. When you're at a conference, it's a period of time where you're working, right? That's the period of time where you get paid. After you're working and you're going out for dinner or you're at your hotel room or whatever it is, that's your personal time. The fact
Mhm.
that it's not at your own house, and that's why a lot of people believe, well, if I can't be at home and I'm being told I have to be here, then that should be work time. In fact, it's not. It doesn't meet the definition of work under the act. The ambiguity comes, and I know with us being in Calgary next week, Brett, like this will be, use the example, is when you go to that dinner afterwards. That is part of the event. That's the ambiguity. Is that a work event or is that, a non-work event? You can make an argument. It's really it's a matter of gray, but for the most part, it's pretty clear if you're working by the definition of work under the act, you need to get paid. When you're traveling for work, you need to get paid. But if you're not working, even if you're away from home, that's not work time.
Okay. Can you force an employee to take their vacation days? And if they don't use them, can we take them away?
To do the latter first, no, you can't. The legislative, the statutory amount, use it and use it or lose it policies are illegal in Canada. The statutory holidays, the statutory vacation pay that they receive is theirs. It's not a benefit, it's an entitlement. An entitlement meaning something that belongs to them. So if they don't use it by the end of the year, you can carry it over, or you can pay them out. That's up to you. If you had something in writing that stated for any vacation time over and above the statutory minimum, if you don't use it, you lose it, you can do that. So that's that question. As far as forcing them to pay, there's two things. BC is actually unique on this thing. BC has actually a provision in their ESA where you can force an employee to take vacation time if you can show an actual shortage of work. Super valuable. Especially when we were doing through COVID and things of that nature, because obviously not every employer has a layoff clause. But if someone had 2 weeks of vacation and you could show that you had an actual shortage of work, you can direct that employee to take those 2 weeks vacation. Alternatively, just as vacation planning goes, whenever you have a policy that says we do not allow carryover, you have the right as an employer to tell somebody, listen, it's September of the year, you still have a week left. We don't allow carryover. You need to book your vacation. You need to book 5 days before the end of the year, or we're going to book it for you. It's completely within your right.
Okay. Um, we have an employee on maternity leave. Are we required to provide them with their vacation time when they are on leave?
You're required to provide them with vacation time, but not pay. So this is something that most jurisdictions have this law and this distinguishing kind of thing. And believe it or not, most employers are still not aware of it. Most employers will either not give them anything, thinking that's what it is, or give them everything, which thinking that's what it is. In fact, vacation time and pay are two different things. You can't discriminate against somebody for being on a protected leave. So you can't take away their vacation time. So they continue, say it's 2 weeks, which is the minimum. So let's say they continue to accrue their vacation time where they're on a 1 year maternity leave, for example, right? Vacation pay is based on earnings. And because they're not actually earning anything while they're on maternity leave, they get 4% of nothing. So at the end, in effect, at the end of a maternity leave that lasted 1 year, if an employee had 2 weeks vacation, they would walk away from that maternity leave with 2 weeks of unpaid vacation time that they're entitled to.
Okay. Interesting. Okay. Can we include non-competition clauses in the agreement for our BC employees? And what is the difference between a non-competition clause and a non-solicitation clause?
Yeah, we had a question on that on our employment agreement thing, so maybe it was something that was missed. I'm not sure, but or similar to that, anyways. In Ontario you can, in BC you can. So Ontario at this point is the only province. I expected BC to follow by now already. To be honest with you, I'm actually surprised they haven't. As it stands right now, you could still put a non-compete in British Columbia. I'm not a fan of non-competes. 80 to 90% of them do not hold up in court because we still are a civil law, with the exception of Quebec. We still are the civil laws Quebec, with the exception of Quebec, we're still a common, I know, we're still a common
Okay.
law
Yeah.
country, which basically is a theory of equity of fairness. One of the theories of equity and fairness is people have a right to make a living. So when you have a non-compete typically looks something like this. If you work in an industry and you quit or you get fired from your job, you basically agreed when you started there that for the next year or 2 years within a specific geographic area, you cannot work in your industry any longer. That flies in the face of common law principles, right? Which is the theory of equity and fairness, which because you're basically telling that person, in order to work in your industry, in order for you to make a living, you have to wait a year or two, or you have to move, right? So most non-competes don't hold up. Non-solicits, if written properly, are incredibly effective, and the courts actually have shown a general pendant to actually enforce them at every turn when they can. A good non-solicit basically says you can work in the industry, you could even work for a competitor. You just can't steal our clients, you can't steal our proprietary information, you can't steal our employees, you can't exchange, price. Basically, everything that's yours that was protected confidentiality wise, proprietary clients, other employees, you can't touch it. And for a certain period of time, usually 1, 2 years max, you can't touch it. Courts have looked at that very favorably because it's a reasonable. It's a reasonable answer that, yeah, go make a living elsewhere, but you can't rob your old workplace after you've been terminated or you left. And usually where you see the enforcement and the support by the courts is when the employers do take former employees to court based on a non-solicit, and the courts have looked at that very favorably, even in the last couple of cases, even provided awards that were greater than what the employer originally asked for.
Interesting. Okay, we're almost out of time here. Any advice for employers who have high technology professionals who have with high technology professionals who have employees who tend to work lots of unpaid time? Can this ever backfire on the employer if it looks like employees are being taken advantage of, i.e., not getting overtime pay for hours worked beyond 8 hours a day?
Yeah, in most cases, high technology professionals are exempt from overtime. So, that's something you might want to look into, or if you're an HR cover client, simply call in or email in and we'll look into it for you. But in most cases, they're exempt from overtime, so that's a non-issue, provided you have that written in their employment agreement. The other thing that's important about your employment agreement in a case like that specifically, let's say you have them on a salary, for example, and the salary says you will get paid the salary to work 40 hours a week. It says those exact words. Your salary is based on 40 hours a week. Any hours they work over 40 hours a week, you have to pay them for, because your employment agreement said specifically your salary is based on 40 hours a week. If your employment agreement says something to the effect, you will work an average of 40 hours a week, more work may be required, or you may work more hours as required, you're fine. So you have to worry about that. The only other thing you need to be concerned about is the maximum amount of hours they are legally allowed to work in the province without actually signing an agreement to forgo it. So those are the three things you really need to look into. I know that's a lot all in a quick question, but when you watch the re-recording, hopefully you can take them down and point forward.
Perfect. Well, we got about 60 seconds left. Again, this is being recorded. It will be sent out on Monday. We have 7 questions that we never got to. I apologize if we did not. But you can always become an HR cover client if you're not one already. And if you are, just submit your question, and we are very fast, under 1 hour to resolve your issues. Darcy, thanks very much. Very interesting. It's always fascinating to learn about how different provinces, go about things in a different way. I know Ontario and BC are very similar in that aspect, but there are differences. And
Sure.
so thanks for getting into that. Again, thanks, Darce. See everyone. Thanks for joining in, and hopefully you learned some stuff about HR in British Columbia. Thank you.